Item number 3.
My lord, I appear for the petitioner, my lord. This is Section 11 application, but I just come to know from my learned friend on the other side, he's appearing for R1, that R2 has died and he's carrying the death certificate and the particulars of the heirs. If he provides us, my lord, that I'll take steps.
Here and now, my lord, provide, my lord. Here and now,
Lordship keeps it after 2 weeks, my lord, I'll immediately file an application.
Learned counsel for the petitioner states that R2 has deceased. He wishes to implead the legal heirs as party to the present proceeding. He seeks and is granted liberty to take necessary steps. List after within a period, let's say within a period of 2 weeks.
2 weeks, my lord. I'll immediately take out the application.
List after 2 weeks. Like copy with also.
My lord, my original affidavit of service and notice of motion.
Copy with served to me also. This is I supply the particular affidavit of service taken on record.
I shall
also
serve it.
appear for R1.
Grateful.
Keep Item number 4.
Lord, I appear for the petitioner, my lord. This matter pertains to, my lord, unauthorized use of my brand name post termination, my lord. I obtained, my lord, certain interim order. Now, my lord, there was the talks of settlement. Today, my lord, my client has found out, my lord, that the respondents operating the restaurant in different brand name. I have asked him, my lord, to confirm that. If you lordship kindly keep it for a week, my lord, then, my lord, we can confirm, and if there is no operation, we can proceed for arbitration.
Proceed for arbitration or you want to withdraw?
My lord, after, my lord,
claim
what?
damages.
Yes, my lord.
Learned counsel for the petitioner prays for an adjournment on personal grounds that this matter be adjourned for 2 weeks. Item number 5.
My lord, this is that matter, my lord, where I had made an offer, my lord, that if they agree to go before the arbitrator on all issues, it can be thrashed out there. But my learned friend is not agreeable to that.
Not my learned friend's clients. Because of obvious reasons, this is not tenable at all.
So, my lord, then I was addressing your lordships, my lord.
Yes.
My lord, this is the case where, my lord, there are several work orders whereby, my lord, the petitioner has supplied, where is the hard copy of the brief, has supplied machinery and cranes to the respondent, my lord, under different work orders. And, my lord, each of the work orders, my lord, contains an arbitration clause. My lord, I had shown the work orders on the last occasion, but if my lord has page 22, this is a standard arbitration clause, my lord, which is there in all the, show page 22, which is there, my lord, in the various
6 work orders.
6 work orders. And my lord will see page 22, my lord. Kindly have the arbitration clause, which your lordship will find at page 25. Page 25, my lord, in the event of any difference or disputes arising out of or in connection with this work order, same shall be first amicably settled. If parties fail to settle their disputes or differences, then, my lord, to arbitration, it shall be conducted by single arbitrator. This, of course, is to be ignored. And the venue will be Kolkata. And my lord will also see that in many of the work orders, my lord, I had shown there is also a forum selection clause which says that the courts in Kolkata will have jurisdiction. Now, my lord, this was one aspect of the matter. The other aspect, my lord, was that the total claim on account of these work orders is 2,71,16,627, which, my lord, the particulars of the claim, my lord, may be found at paragraph 15 at page 6 of the petition. And we had also served a notice, my lord. That notice your lordship will find at page 269. Volume 2, page 269 is
I
the
think if
notice.
I remember correctly, Mr. Bagh was saying that these are all separate agreements.
Yes.
That was my.
No, I'm
That
addressing.
was your
Yes. So, my lord, he had
That is the
raised,
reason I could not concede to that
no,
request.
he had raised 3 objections, my lord, principally. First objection is that these are different work orders, although it is between the same party. But the work orders are different for work to be carried out in different parts of the country. So, therefore, according to him, this cannot be referred. This is not, although this is not a section 11, But even then, my lord may go into it prima facie, my lord. Therefore, he is raising an objection that this cannot go into in a single arbitration. His second objection was that there is a bar of limitation. He says that this is beyond 3-year period. And although even so far as this is concerned, my lord, in my humble submission, would look at it prima facie, because I mean, limitation is a mixed question. Eventually, it is for the arbitrator to decide. And thirdly, my lord, he said that merely because is poor doesn't mean that you can seek an order under Section 9. So this was broadly his three submissions. Now, for the first point, my lord, is fundamental, because, my lord, if I am not able to cross that, my lord, if it is not arbitrable, although this is a Section 9, but even then, my lord, this issue has arisen before learned single judges of this court, my lord, in the past. My lord, I'll just show, my lord, three of judgments. First, my lord, may have Sonia Dhar. The decision, my lord, in Sonia Dhar. Give that. Sonia Dheer, sorry. It not okay, the original noun. Kindly see, my lord, this order. This is at page. Again, my lord, this is in section 11, because, my lord, I reiterated this submission. This argument, my lord, my notice under 21 has been given. Sooner or later, there will be section 11 where they will again raise this objection. But, my lord, kindly see, my lord, how the court has dealt with this issue in section 11. Kindly have, my lord, page 5 of this order. There are, kindly see the second paragraph. There are several circumstances as discussed by the learned single judge in Ganapati Technology. I'll show that also immediately, where there can be composite references. One being where there is mother and ancillary agreement, which is not exactly the present case. As with our case also, this is not a case where there is a single commercial project to be achieved by two agreements. Rather, the facts of this case are akin to third limb, as discussed in paragraph 21 of Ganapati, which envisages two or more contracts which are intertwined with each other so as to prejudice the parties would if separate arbitrations were held. Conspicuously, in clauses 2 and 3 of the service agreement, it is clearly stipulated that services under the said agreement are to be provided at the licensed premises. The service agreement in several places relates back to leave and license and connects itself with providing service in respect of licensed premises only. Importantly, clause 4 also provides same as co-terminus and concurrent with leave and license. Again, leave and license provides several rights to be enjoyed by the respondent in respect of the premises for which the service agreement. Thus, there can be fourth situation that is envisaged in the cited decisions, where although both the agreements may not achieve a common goal or objective, as such, the underlying jural relationship, which is the common platform of both the agreements, may be the same. In the present case, the jural relationship, that is licensor-licensee, created between the respondent on the one hand and the petitioner separately on the other, pertain to enjoyment of the self-same premises. The said jural relationship together forms a common fabric, the leave and license agreement, which confers rights on respondent to enjoy property which provides services. Thus, common underlying jural relationship vis-a-vis property is a unifying factor. Hence, I find that in the event there is separate reference to arbitration with regard to two agreements, where the set of transactions and developments leading to the disputes would be common, there is ample scope for unnecessary multiplicity of proceedings. Now, in my case, my lord, what is the jural relationship? The jural relationship is I am supplying machinery. Now, this machinery, and it is my contention that
Mr. Satadharu, as far as the machinery is concerned, there's a separate agreement you are getting into. All these cranes which you are supplying to him are for different location, different project, different things, right? As far as the license fee is also concerned, it would be different license fee which you are charging for it. Two, as far as this case is concerned, it is one premises which is being used. So there's a jural relationship where the premises is the same, but there are two different agreements which they are, probably the parties have entered into. But in your case, these are all separate work orders which have been issued, maybe for different projects, different places, different cranes. How can you have a common?
my contention is, and I'll show, I understand, my lord, what is following. I'll give a more specific. I should have shown that first. My contention is that it is a running account. So, my lord, the relationship, there is a common jural relationship, and under a running account, my lord, this is being done because the payments they have made in August 2025, the last payment, not against a specific work order. Ad hoc payments were being made. Now, kindly, my lord, but to address your lordship, my lord, I appreciate, my lord, what is following from your lordship. Kindly have the next order, Surya Jyoti. Give Surya Jyoti. Kindly have the decision in, this is more similar, my lord. In fact, I should have shown this first, my mistake. Kindly have this order in Surya Jyoti Renewables Private Limited. Kindly have para 22. This is in the context of, kindly see para 22. Admittedly, the purchase orders and service orders were accompanied by terms and conditions which contained a dispute resolution clause. All the dispute resolution clauses accompanying the purchase orders and service orders were similarly worded, which is our case here too, and the parties had agreed to settle all their disputes by reference under the provisions of Arbitration and Conciliation Act 1996. The arbitral tribunal was to comprise of 3 persons. Each of the, here also it says sole arbitrator to be appointed by me. Each of the parties would appoint their nominee, and this is the procedure in that case. The fact that notice of invocation of arbitration clause was received by respondent via email is not in dispute. Notice by received by speed post. Respondent also replied and refused to refer. Application before this court. Respondent disputes the claims of the petitioner and made the petitioner liable for breach and consequences, but did not deny the existence of arbitration clause. Now kindly see next para. The petitioner, being an MSME, had approached but withdrawn the proceedings from the council before its, in view of nature of the work and also in view of arbitration clause. It was specific contention. Now this we are not concerned with. Now kindly see para 24. It is a settled proposition of law that learned arbitral tribunal can rule on its own jurisdiction. With regard to prayer for composite reference and objection raised by the respondent, this court prima facie finds that often composite bills are raised by the petitioner. Composite notices were issued by the petitioner for payment of the outstanding. It appears that parties agreed for joint instances on the facts. Allegations and counter allegations were made. Series of communications. Finally, notice of termination. Now kindly have, my lord, para 27 at page 11. Thus, this court is satisfied that a composite arbitration will be beneficial for both the parties as the issues are interlinked and interconnected. Parties have treated the same as such. A composite reference will prevent wastage of time, save multiplicity of proceedings, and will also be cost effective. Then, my lord, will see para 29, a composite invocation under section 21 pertaining to the consolidated claim of the petitioner in respect of purchase orders and service orders, and the challenge to the termination of the purchase and service orders cannot be held to be invalid. Invocation notice clearly indicates the details of the purchase orders and service orders and nature of the disputes. The communications via email with regard to issues also indicate all along parties have treated the purchase and service orders as part of same business relationship. Under such circumstances, application is allowed. All questions relating to arbitrability, etc., shall be raised before the arbitral tribunal. Now, this is similar facts, but the principle, my lord, was laid down for the first time in the decision by this court before this court in Ganapati. This is the order, my lord, which was referred to in the first order also, which I had read, my lord. Kindly have para 21. Kindly have para 21 of this order. Kindly see
Page.
This is, my lord, SCC page 6, top of that.
Yes, yes. Para 21.
Yes, para 21. Now, this is, of course, looking at two situations. The first part is regarding mother and ancillary agreements, which we are not concerned with. But kindly have the last line, which is what was relied upon by the learned single judge in Surya Jyoti also. Again, if there are 2 or more contracts and they are so intertwined with each other so as to prejudice the parties should separate arbitrations are held, then a composite reference can be made. Now, in our case, my lord, the notice, my lord, the notice of demand which I have raised at page 269 is composite. I have said that these, kindly see page 269, volume 2. Kindly see page 269. This is a demand notice which I have raised.
Yes.
This, kindly see, we say over here that my client is a well-known heavy earth mover and equipment crane service with necessary equipment provider and other services. You introduce yourself as such and such. Then kindly see next page, being at page 270, being convinced of your representations and relying on your commitments of assured prompt payment, my client rendered its service as and when you requested, worth several thousand during the period under invoices raised from time to time. My client maintains running accounts. In usual course of business, my client rendered its service from time to time worth, this is the total amount of service that was done, wherein you jointly, severally, in admission or undisputed liability, paid a sum of 1 crore 81 lakhs, leaving behind principal unpaid invoice as on date for 1 crore 27 lakhs. You received the service of my client without demur or objection. Um, Utilize the service from time to time for commercial gain, jointly and severably defaulted on payment of the invoices. Despite the fact that you took the service, you have full acknowledgement of the debt and acknowledgement of liability. In meeting held at my client's and the addressee's office, herein you agreed, accepted, and admitted that you should clear the entire dues on or before such and such. You neglected to clear, and then accordingly, my lord will find. You will accordingly, my lord will find that the demand is raised, my lord, for this amount.
Who's this Salarpuria?
My lord,
Salarpuria, who's this? What's the name of the director?
my lord is
Salarpuria. What is the name? It's some gentleman's name.
this is my lord Salarpuria Simplex Realty Ventures. So this is one of the group companies of the Simplex Infrastructure.
Not the one.
Right.
Take note. Let this matter be listed before another bench subject to order of the Honorable Chief Justice.
Milord is keeping this on some other day, Milord?
My lord,
Releasing it.
Not sure.
Think-
Then the company, Milord.
Salarpuria.
My lord. No, it's recused. My lord.
I was eager to argue before your lordship these points because I had to show Milord a lot of facts.
That's the landlord. I'm renting the place.
Oh, I see. Not sure.
My lord. And we'll have to then take steps. If you take steps, get listed.
I'm very deeply obliged, Milord.
This from this board. Matter is released. Let this matter be placed before the Honorable Chief Justice for appropriate actions.
I'm deeply obliged, Milord.
Loss is ours, my lord.
Loss is absolutely ours, Milord. Milord, we do not have, because
It's not right, Mr. Nath.
We do not.
Look,
On instructions, we have no difficulty.
we also don't have any difficulty.
I'm not comfortable.
Lordship, will not then, Milord. Will. Very deeply obliged.
In today's time, better to
Deeply obliged, Milord.
Our application is the post award section 9 application, my lord. And file this application, we have served them. We have affidavit service. We have only praying, my lord, for direction upon the respondent to secure the claim, my lord, which the arbitrator has been passed in our favor, in favor of our client, my lord. We want only that. We have able to a certain bank account, timing one, the injunction upon them bank account, not to use that.
served everyone. Mr.
I have served, my lord. I filed affidavit service. Basically, I am paying injunction against the one, against one only, the Jumbo Finvest India Limited. Awardee number one, he is the holder of the bank account, which we have described in paragraph 23.
Let's see that.
23, the description of the bank account is there. Paragraph 23 of the petition.
23.
23 of the petition, my lord. The description of
Yes.
the bank account.
Twenty-three is what are you trying to show from here?
This is the for the bank account, which we came to know that is the open in the name of the respondent number one.
23 is your documentation to be given by NBFC. What? Page 23, right?
No. Paragraph 23, page 10, my lord. Sorry, my lord. Paragraph 23, page 10.
Bank account mentioned in para 20. So you want to restrain against these bank accounts.
Yes, my lord. And my lord, in the page 9, my lord, paragraph 17, we have described, my lord, the award has been passed and what is the awarded amount, we have also mentioned that. In paragraph 17, page 9.
And this arises out of the loan agreement
Out of the
dated
loan agreement, my lord, loan agreement is as page 27, my lord.
28,
20
23rd May 2019.
Yes, my lord. The loan agreement, page 27, there is also forum selection clause that only the Calcutta High Court is Calcutta is the competent court. In Calcutta is the jurisdiction over the subject matter and the venue of the arbitration is also in Calcutta.
Page.
Page, my lord. Just
The first schedule action. Page 66 is the amount, 5 crores.
Page 62, my lord, is the jurisdiction clause. Page 62, clause number 16.17 and 16.18. The jurisdiction and arbitration clause, my lord.
Alright, take down. The petitioner has filed the present petition under section 9 of the Arbitration Conciliation Act, seeking interim protection by way of restraining the respondent from operating the bank accounts mentioned in para 23 of the present petition without present petition, maintaining the balance equivalent to the awarded amount.
I have to also point out, they have also filed 34 applications that is appearing before the Honorable Court in the monthly list, but they have filed 34 applications challenging the award. That we have to also. That is there.
Learned counsel appearing for the petitioner submits that the petitioner had provided financial assistance to the respondent for a sum of rupees 5 crore under a loan agreement dated 23rd May 2019. Full stop. It is submitted that the respondent defaulted in repayment of the said loan amount, which resulted in disputes between the parties. This court, by order dated 28th August 2023, had appointed Honorable Justice A.K. Ganguly retired as the sole arbitrator to adjudicate the dispute between the parties. Learned counsel for the petitioner submits that the learned sole arbitrator, by an award dated 4th December 2025, allowed the claims of the petitioner and awarded a sum of rupees 53609,880 in favor of the petitioner. Full stop. Learned counsel for the petitioner submits that although the petitioner is entitled to execute the said award, the petitioner is still available. The sometime is still available to the respondent. No, the learned counsel petitioner submits that though. Then why didn't you file an execution? Why have you come in section 9?
Because the post award, the 34 is pending. We can file an execution, can grant a time being the injunction order. In the meantime, we will also take out because they have not a security amount. They have filed only section 34 application and under section 32, subsection 2, they have not filed.
Why should I unnecessarily file an execution petition if they have filed a 34?
But when we have filed this application, time to file execution has not been matured.
That's right.
3 months for
Now it has matured.
now it has matured, but
File an
time being
execution.
we want due to passage of time now it has been matured, but I'm praying only give the limited time,
File an
injunction.
execution, Mr. Bhatt.
Then I will take out the execution and pray for same prayer, but
For the same prayer.
but at least 2 to 3 week protection, whatever my lord can feel, my lord can grant it.
Hey, why should I entertain this section 9 there?
Because my lord, they have already filed section 34.
Alright.
That
They are challenging it.
they are challenging the award, and the section 34 is pending. We have a right to file in section 9, and we have
right
also
I'm
right
not
to.
saying you don't have a right, but the correct
We can also file
would
execution
be
because
execution.
yes, that we can file, because they have not a security amount. We have a right
Come
to.
back next week with the execution application. We'll pass
Yes,
an order.
I can do that also. I
Come
can do
back
that.
next week with the execution. Learned counsel, you withdraw this, Mr. That's your file execution. Come back next week with the execution. We'll.
Yes, yes.
Learned counsel for the petition seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. Full stop. The said liberty as prayed for is granted. The present petition is dismissed as withdrawn. File your execution.
Seven.
Seven, your lordship would recall this is that matter development agreement. No agreement stipulates no termination clause. 95% of the work has been completed, more than 95% in fact. For the residual few percentage, I suffer a termination notice. Your lordship, now the contract stands terminated without any eminence from the principal agreement. Your lordship, I was seeking a stay on the termination notice. Your lordship, in the meantime, I had proposed, your lordship, if this matter could be sent to arbitration.
My lord, there is a claim and counterclaim is present. My lord, it's a live dispute. My lord, it's better, my lord, to refer the matter to arbitration
in
because
fact,
there is a valid arbitration
We've
clause. with the-
also sent a section 21 notice. Your lordship, this is the only prayer that I'll be making. Your lordship, of course, subject to your lordship's guidance. Your lordship, for the time that I go before the learned arbitrator and file my section 17, till the time I file my section 17, lordship makes it a time-bound process of 2 weeks or 3 weeks. Let there be a stay on termination. Your lordship, then otherwise,
But
your
in
lordship,
the
I will
meantime, my lord, what has happened? My lord,
Can't do
termination
that.
has taken place on 15th of February. Today
Yes.
we are in
no, of
today
course.
we are in
We have,
July.
your lordship, of course, I
My
agree to
lord,
that.
they have approached the court much later. My lord.
Your lordship, may I
Let all the
join
matter
issue
be-
with that. Your lordship,
let all the matter be
Go before the arbitrator.
before the
Your lordship.
arbitrator. That's
I will,
You
may
file
I
your
just indicate?
application
Your
for
lordship,
stay of the termination order or whatever.
we'll
it
do
is.
that, your lordship. May I just indicate one?
In section
Term-
11, I will not grant you any.
No, this is a section 9, your lordship.
Section 9, I will not grant you any relief at this stage. If I'm appointing arbitrator, they should be treated as a 17 before the arbitrator. Let him decide.
Your lordship,
I'll put it as 17 before the arbitrator.
yes, your lordship, I bow down.
I'll
to that.
appoint the arbitrator in section 9, treated as 17, go before the arbitrator.
Your lordship, then, your lordship, may I propose this once? Of course, again, subject to your lordship's guidance, of course, your lordship. We have come before the 15th February termination. We filed in March.
Yes.
We've mentioned 6 times, your lordship. Of course, due to the burden that this
Yes.
court has, it's impossible, your lordship, to take these matters. However, your lordship makes it a time-bound process of 1 week. Would your lordship be pleased to make this observation that this court hopes and expresses hopes and prays that till the time the arbitrator is in season of the matter, they will not take any adverse steps because your lordship, my
Is
goods are there.
literally
No
Classic
adverse
in order.
steps is taken, my lord. The project is lying like that.
No,
my
no,
lord.
it is not. Your lordship, I have filed a supplementary affidavit wherein your lordship, I have enumerated that they are taking my workers. Your lordship, I am the contractor. They are taking my workers, paying them separately, and your lordship, they are your lordship constructing the residual portion
My
with
lord,
my goods which I have bought. Your lordship, bills and everything I have annexed in the section.
that
which is
they
right.
will that my
Sorry,
lord, that
one.
For that, you
Please.
could have taken separate action. You can approach the cop. You can go to the police station.
there are two criminal cases are pending, my lord. There are two criminal cases also pending. One taken out by them, one taken out by my client. So everything is there. My lord, everything will be sorted out
Criminal-
before the arbitrator.
No, your lordship, criminal aspect of it, may I, your lordship, let me not trouble your lordship with the paper. At the end of the day, your lordship, as an officer of the court, I am saying this, lordship, this is ultimately an ego battle. But your lordship, today, my goods are lying in the premises. What happens to those goods, your lordship? Just the limited protection with respect to those goods, your lordship. Nothing else.
My lord,
Nothing
the
else.
answer is, my lord, the goods is amounting some money. My lord, they will ask for that money. They will ask before the arbitrator. The arbitrator will decide the issue.
No, no, your lordship, that cannot be because your
Because
lordship.
they have
Just
stated
a
it.
minute,
Sir,
sir.
allow me to just
No, no,
kind- sorry,
Okay.
please. Your lordship
Running
will
commentary can't help us.
your lordship, your lordship knows your
He's
lordship.
a young boy. You should allow him to speak.
Definitely.
He's a younger member of the bar. You should show some sympathy towards him.
Your lordship, the basic law of damages, as your lordship, we have learned it. Your lordship, I have to mitigate my losses. So, your lordship, if I'm allowing my goods to lie there, your lordship, without taking any steps, your lordship, the question of
All those
mitigation, I
things
won't
can be
meet.
looked into by the
Except-
arbitrator.
Lordship, क्या करना है? My instruction that if that limited protection could be granted. Your Lordship, because 3% of the work is left. I am not asking for an injunction. Your Lordship, if that observation could be made, Your Lordship, at the end of the day, every litigation, Your Lordship,
If I make that observation, the arbitrator will be influenced by it.
no, Your Lordship, we will clarify that the arbitrator will consider it afresh, Your Lordship. Just till the time I go before the arbitrator, because Your Lordship, today Your Lordship passes the order, it will take me at least 7 days, Your Lordship, to Your Lordship.
It's a terminated contract. Literally, it's like a restoration of a terminated contract.
Your
I
Lordship,
can't
there is no
restore
basis of the termination. No
whatever it is. I can't look into it. That arbitrator will look into it, whether there's any basis, whether the termination is valid, invalid, whatever it is. I can't decide your termination. And that is literally putting you back into the place after the termination. Can't do that.
Then Your Lordship will allow just the goods. Your Lordship will protect me with respect to the goods that are laying.
Whatever it is, you're entitled to the protection before the arbitrator.
I am, Your Lordship.
Yes.
But all I'm saying is, Your Lordship, that intervening
I
period
can't give
of
that.
of 1 week that will take me to go before the arbitrator.
Sorry, sir.
Your Lordship, I am not, Your Lordship, may I, Your Lordship, since Your Lordship is not deciding the Section 9 on merits, Your Lordship, I had
I'm not.
I had one judgment, Your Lordship. I am not supposed to ideally rely on it because Your Lordship is not deciding on merits. Lordship, the point I'm attempting to agitate, Your Lordship, is that, Your Lordship, this is of course not a mini trial, but Your Lordship, prima facie, if I can at least show to Your Lordship that Your Lordship, the termination has no eminence from the contract where it has emanated from. And Your Lordship, the conduct as to why the termination has been made, because Your Lordship, they don't want to pay me the 3%, the valuation of the 5% that is left, Your Lordship, as of today. I am not asking for a security of that sum, nor am I asking Your Lordship. In fact, if I pray before Your Lordship, for Your Lordship, for Your Lordship to allow me to construct, Your Lordship will recall, I have in fact made on many submissions on the other side saying that then, Your Lordship, this will become a suit for land. This court will not have jurisdiction. Then I'll have to go before the Rajahat Commercial Court. I can't make that prayer before Your Lordship. I am only, Your Lordship, praying that Your Lordship, let the termination not be acted upon. And Your Lordship, my goods that are there, just my goods, that is it. Because Your Lordship, with respect to for me to commence the work, that I cannot pray before Your Lordship. It will become a suit for land. This court won't have jurisdiction, which is why, Your Lordship, I am not pressing for that prayer. I have not made out those prayers in my application.
We don't know. Till the time you don't really have a receiver who can make an inventory of the goods, we don't really know what goods are yours.
No, Your Lordship, that we have given the bills. We've given the bills. May I just show? Your Lordship will kindly see the bills which I have given at page number
Sir,
114.
go before the arbitrator, raise all these points before the arbitrator. I'll put this as a section 17. Learned counsel for the take down. The petitioner has preferred the present petition under section 9 of the Arbitration Conciliation Act, seeking various interim measures in relation to the construction contract executed between the parties for a project situated at premises number 93/9222, plot number DC 203, action area 1, Newtown, Calcutta. Full stop. Learned counsel for the party. At the outset, learned counsel for the parties state that the present application shall be treated as a section 11 petition, and an arbitrator can be what are learned counsel for the parties. At the outset, learned counsel for the parties state that an arbitrator can be appointed to adjudicate the dispute between the parties. In view of the same, with the consent of the parties, this court appoints.
Lordship, first senior Mr. Moinak Bose.
Give a name, Mr. Moinak Bose.
Moinak Bose.
Mr. Moinak Bose as the learned sole arbitrator. As a learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned arbitrator shall enter reference in due compliance with section 12(5) of the said act, of the act. Full stop. He shall be entitled to fix his remuneration in terms of the fourth schedule or with the consent of the parties. Full stop. The present petition under section 9 shall be treated as an application under section 17 before the learned arbitrator to be decided on merits. Full stop. All points related to maintainability, arbitrability, limitation or any other issue shall be kept open before the arbitrator to be adjudicated upon. Full stop. A copy of this order shall be communicated to the arbitrator to take necessary steps. Full stop. With the aforesaid direction, the present petition stands dismissed.
May I prefer just one line? Parties are at liberty to act on a server copy of this order.
Parties are at liberty to act on the server copy of.
I'm so grateful to you.
My lord, item number 8, I beg to appear virtually, my lord, with my lord's permission.
Yes,
My lord, this is my section 9 application, my lord. I moved a similar application on a previous day, my lord. This is the third count, my lord, we've served. My lord, this time, my lord, the respondents number 1 and 2 have been served. They are the principal borrowers. The respondent number 3, my lord, is a guarantor. He's possibly not required because he doesn't have the machinery with him. But I was praying for receiver, my lord. Respondent number 1 and 2, they've refused service.
All right.
My lord,
You
I'm
have
carrying.
Yes, you are carrying that with the
Yes,
changes?
yes, but I'm carrying a hard copy of that order. My learned colleague is there, Ms. Purohit. May I
With the
request?
changes?
My lord, my lord, the changes, my lord, may I just indicate to your lordship, my lord, only one change, my lord, the asset. In fact, the only other thing, my lord, that I have to bring to your lordship's notice, my
What
lord, in
about the
this,
agreement number and all that? Have you made those changes?
no, my lord, that I don't think Ms. Purohit has done. But I should have, in fact, looked at it myself.
You should have done
With,
that. Mr.
my
Naik would have made my life easy.
lord, I'm not physically there, my lord, which is the only reason I couldn't. Otherwise, I would have definitely done it, my lord.
Will you do it in the course of the day?
Yes, yes, absolutely. I'll hand it up. Only one other thing, it's possibly not reflected in the order that's been handed up to your lordship, but your lordship will recall in a previous matter, my lord, there was an intimation which was made to the borrower, pursuant to which, in the other case, the borrower had made payments
Yes.
to the assignee. My lord, in this case, I'll be very candid, my lord. I have not been able to obtain the instruction from my solicitor if there were payments made post intimation. But that is slightly, my lord, redundant because I don't think that intimation is necessary because they have the right to, my lord, assign anyway, and the termination they've received anyway for non-payment. But that, my lord, I wanted to bring to your lordship's notice nevertheless.
All right. So and so is appointed as the receiver. Give the make the correction. Give the copy.
I shall do that, my lord. I shall do it in the course of the day.
They'll give a corrected copy. Just make the correction to the loan amount, the loan agreement number, the date, and the amount. All
And
right?
the asset, and the asset, my
And
lord.
the asset. Just
And the
give me
asset.
all the 3 changes and give it to me.
I will, may I, with your lordship's leave, my lord, make the correction on the order itself with pen.
Yes, yes.
Yes.
Do that.
I'm very grateful. I'm very grateful to you.
They'll give it to next. Yes.
Your Lordship, I appear on behalf of the petitioner, Your Lordship.
Yes.
In the last order, Your
Your Lordship, I
Lordship,
beg to appear on behalf of the respondent. Your Lordship, we have received the brief yesterday. I'm praying for just 1 day's accommodation to seek further
Lordship,
instructions.
we had, as per the last order, we were directed to serve upon the respondents. We had served upon the respondents on 23rd June.
He's appearing.
Yes, Your Lordship. Your Lordship, I'm led
Lord-
by Mr. Samriddha Sen, Your Lordship. He's
Where is he?
appearing virtually.
Where is he?
Your Lordship, I'm praying for a short accommodation, Your Lordship, and not
Monday. Just take down affidavit of service taken on record. Learned counsel for the respondent states that he has just received the copy of the brief.
Yes, sir.
Prays for an adjournment. Let this matter be adjourned to Wednesday.
I'm grateful. Ma'am.
Wednesday, huh? You appear for all the respondents?
Yes, madam. I'm praying for both the respondents.
Respondent number 1 and 2. Huh?
Sure. At not 10.
May it please your lordship, my lord. I'm appearing on behalf of the petitioner in this matter. But at the outset, my lord, I must indicate this section 9 application arises out of an arbitration agreement where, my lord, there is an exclusive jurisdiction clause. The exclusive jurisdiction clause, my lord, says that Milord, it either is going to be Delhi, and it is congruent because the borrower is Milord, a resident of Gurgaon. So Milord, that has natural jurisdiction. Milord, Ugro Capital, that is the lender, has its office at Mumbai. So there is also Milord, Mumbai as the alternate jurisdiction clause. There is also Milord, a further reading of this understanding, which says, however, this shall not limit the right of the lender to take proceedings in any other court of competent jurisdiction. Now, Milord, why I have indicated, I understand, Milord, yesterday I was there in court when your Lordship was expressing the mind. This line was not there in that contract, but I may find, Milord, Kolkata has natural jurisdiction, of course, because Ugro Capital has its office, Milord,
Doesn't
within
matter.
jurisdiction.
Doesn't matter.
But I've seen the pleadings also. That conclusion of contract pleading is there.
Absolutely.
Milord,
Go to
will it
Delhi.
be your Lordship's kind pleasure to keep
Go to
this matter
Delhi.
next week? I only want to cite one judgment. This is the one which
Whatever you are going to cite, I will not entertain. Go to Delhi.
exclusivity,
No,
or either Delhi or Mumbai.
or Mumbai. Whatever.
Kindly
No.
keep it next week, Milord. I will. Mr. Pandey is here, and I'll speak to
Mr.
him.
Pandey he knows the court very well. Mr.
Because,
Pandey,
Milord,
Mr. Pandey knows
exclusivity is
the
not there.
mind of this court very well. He's here.
Milord, perhaps in those matters only Delhi was there. But here, Milord, the exclusivity is not happening. If a person says that it is going to
You
be,
will have observations. If you want me to decide it, then I'll give observations against your company.
that is the difficulty.
I'll 100% do it.
I
Because the
understand.
manner in which it is being done, this can't be.
I rest it here. I'll come back next week and Milord, we'll
This
see.
can't be. No cause of action, the loan. Similar issue I faced in one of them. And I'm going to call the CMD. I'm seriously going to take it to the logical end. This is not done.
But Milord,
This is harassment to the other side. Loan dispersal, agreement signed, everything done there. You can have offices everywhere. You can have office here, you can have an office in Chennai. This is like you feel like filing it wherever you want to. Nothing has happened here. Still you want to file it here. I will not allow that one. And don't take observations.
no, I will not, Milord, press any further throttle on this.
When do you want? Next week or you want to withdraw today and
Milord, kindly keep it next week. We have understood, Milord, what is going to be the fate. And we have to, Milord, because I see these matters come in bunches. So, Milord, one observation of your Lordship will have an effect on the others. So, we must
in the
inform
last
the
one,
client what it is about.
the signatures are digitally done. They have forced me to pass an order where I'm going to do a fact finding to ensure that the signatures are signed in Gurgaon. And then I'll issue perjury against the person who has filed it here. And I'll do something about it. Again, a financial institution. If they think
With
that
the
they
Information Technology Act,
can
Milord,
use these
clear on
forum
this.
like this, wherever they feel like, it's not right.
It cannot happen because Information Technology Act Section 16 says when there is a electronic correspondence and incorporation of digital signature, the usual place of business is supposed to be the place where these things must have taken place.
Must
So
have.
naturally, a person can do it even when he's in train or
Correct.
when he's in
And he's
moving.
sitting there. When you're signing it digitally, you also have the place from where you are executing it.
That place is reflected.
It's reflecting.
We will not take steps on this.
When Wednesday,
Next week, no,
Monday,
kindly
Wednesday.
keep it Wednesday.
Not today. But as lawyers, you should advise your financial.
Sir, I have. In fact, I have. I only wanted to cite this judgment because that talks about the latest position on jurisdiction. I'll have other scope too, other options, other opportunity to cite it before your Lordship.
Absolutely.
Yeah. Section 17. Milord, this is a section 9 application, Milord. Here, Milord, the place is at Kolkata.
Yes.
But here the difficulty is, Milord, the lender company has already, Milord, there is a loan given of rupees 33 lakh. There is an admitted default.
Yes.
Milord, I am under the protection of section 9. But I must indicate to your lordship, my lord, over here,
Yes.
the lender company has already approached an arbitral forum.
You go
Now, the difficulty is that the arbitral forum, my lord, is not, they hope that it is proceeded, but it's not proceeding. This is the situation. My lord,
maintainable. The moment you have an
my lord, what has
arbitral-
happened over here is, I find that it's only pleaded that the arbitral forum is non-functional or is not having full control. But that is not sufficient pleading, my lord, for me to come under section 9, subsection E. My only remedy would be other efficacious remedy. For that, kindly give me an opportunity to file a supplementary affidavit and then test it out, my lord.
Supplementary affidavit bring you
My
the
lord, to
record.
bring on record the grounds, because the arbitral forum, my lord, is not functional in the manner, my lord, it is supposed to. Today there is, my lord, an ODR, and it is expected that the orders passed by the arbitral.
How's your section 9 maintainable at this stage?
My lord, there is an option of section 17 because there is an arbitral proceeding already going on.
Correct.
Now, in a situation, my lord, where the arbitral tribunal is not passing an order or expresses that I do not have control, I cannot abandon the arbitral proceeding then and there.
This is being done by
My lord,
online, ODR online.
Enam,
Sama.
I'll just indicate you. Yes, my lord. SAMA. SAMA, we have pleaded that in paragraph 29 and
Yes.
30. So, my lord, this view which has been expressed by the institutional arbitral forum, my lord, that is something which I have to, my lord, bring before your lordship, and then your lordship may test it out whether I am under, whether your lordship can afford me some protection.
Learned counsel for the petition seeks in his granted liberty to file additional affidavit, bringing on record the proceedings before the arbitral tribunal.
What is it?
Counsel for the petitioner states that though an arbitral tribunal has been constituted, but they have failed to adjudicate the adjudicate the dispute between the party. Full stop. He further states that the arbitral tribunal has shown its incompetency.
Yes, my lord.
Incompetency in proceeding with the arbitral proceedings. Full stop. Let the additional affidavit be filed within a period of
My lord, kindly grants us 2 weeks time.
2 weeks. Let's start at 3 weeks.
2 weeks.
Affidavit service taken.
Execution policy.
The other side has been served, Mr. Banerjee. Other
Yes.
side has been served.
Yes, my lord, there is affidavit of service. We have filed it, my lord.
Affidavit service taken. Oh, service has
Service to the
Oh. the affidavit of service taken on record. The service report indicates that the respondent has refused service. Refusal of service is good service, despite service done up for the respondent. There's only one respondent.
Yes, ma'am. Bolo din.
Okay.
Respondent number, my lord, 1
I can see.
and 1, my lord, the return reads no such person.
Oh,
2 and
then
3 has refused. So, my lord, kindly direct us to serve once again by the returnable date.
इसमें कर दो, यहाँ refuse लिखा है ना, respondent number 2 and 3 has refused.
2 and 3, my lord, it appears to be good
So,
service. We'll
good
serve the
service.
respondent number 1 once again.
As far as respondent number 1 is concerned, the report indicates that no such person stays in the address. The petitioners are directed to serve upon the respondent number 1 within a period of 2 weeks. Affidavit service to be filed on the next date. List after 3 weeks.
One paragraph to that.
12.
May it please your lordship, my lord. This matter, my lord, is my section 9 application, where the sanction amount of the loan is 16,51,000. My lord, I already have an award in my favor. This is my application which I have taken out, my lord, prior to the execution proceedings.
No 34 has been filed.
I am told no 34 has been filed. So, my lord, kindly grant us a limited protection, and just a few matters before your lordship has expressed
Yes.
that we will file our execution. We shall do that, my lord, within the next 2 weeks itself. I only need some protection, my lord, with respect to the 2 weeks time.
So file your execution.
Milord,
time period is
Milord,
over.
I have a legal right. That is all what I am
Yeah.
exercising.
You have
Kindly grant us some protection for a limited period, and will certainly, Milord. আপনি injunction পাবেন, receiver account. Because ultimately, Milord, there is an award in my favor.
yes. When was the award passed?
Yes, award is acceptable.
Award is dated.
Award is unacceptable. 9th June 2025, paragraph 23, it is pleaded, Milord. 9th June 2025. And it is pleaded, Milord, in paragraph 23. Amount.
What is the award? Page.
Milord, the award is not annexed, but I have been handed up a copy of the award, Milord. The condition is not so good.
The Pandey.
No, it's another reason. Have a look at it.
What?
It's by an ODR. So they flow by your lordship's views.
Withdraw this. I'm telling you, don't do this. Lieutenant Counsel for the petitioner says to withdraw the present petition
Yes.
with liberty to file appropriate
No,
proceedings
no.
in accordance with law.
Body will affect whatever.
You know my this will go. Mr. Pandey, you know it. I'll set it aside.
He is, Milord, practically saying that we are concerned with the asset and the recovery. Now, Milord,
I'll file a section 11 immediately. This will go.
section 11 coupled with a section 9.
Yes.
Yes. We'll see to that. You don't, because so Pandey is correct. There is already an award. There is already an award.
Award will get set aside.
But somebody has to do that. And I cannot file a section 11 unless that award is set aside.
File a 34, it will be set aside.
So self 34. These issues are cropping up for your lordship.
File execution, I'll set it aside. In execution, I'm setting aside the awards.
These are all the fearful reactions which come from us.
File execution, I'll set it aside. I've done it in Mr. Pandey notes. All the matters. I'll give you liberty to initiate.
Yes. That is, Milord, a
I'll
way
give
out.
you liberty to initiate.
That is a way out. Limitation also comes in the way. That will be, limitation
you
will be
can-
protected in that.
Correct.
I'll speak.
And you have the protection of 14 also.
Yes. I'll speak.
But I'm giving you liberty also. All the cases I've given liberty.
Very well. We'll take steps. I'm obliged. And I'm sorry.
This is my section 9 application. There was no caveat. We have not served. We are moving, my lord, ex parte. In case, my lord.
Why?
But there's the urgency here is that, my lord, there is a registered development agreement.
Serve
I'm
them,
for the
serve
pro.
them.
Well, we'll come back next week, my lord. Kindly keeps it next week. We'll serve and come back next week.
Lieutenant Counsel for the petitioner seeks and is granted liberty to effect service upon the respondent within a period of 1 week.
1 week, within 1 week, my lord, we'll come back.
Just after 2 weeks.
My lord, keeps it next week itself. Within this time, we'll serve. There is, my lord, some urgency.
List on next Wednesday. When do you want?
Next Friday, my lord, keep
Next
it next Friday.
Next Friday.
Grateful.
And now 14. There was a direction upon me, Milord, to file a supplementary affidavit, bringing on record, Milord, a legible copy of, Milord, the award.
The award.
Milord, file. Milord, may I hand it up, Milord? Milord, there are two applications. One is under 34, one is under 36. Milord, the consecutive items.
Yes. Yes, sir, you are appearing for the respondent?
I'm appearing for the respondent number 1.
Yes.
I've received a copy, your lordships.
Any day, my lord, which is convenient to your lordship, my lord, I can come back.
You're challenging the award only.
Yes. And 36 is, my lord, possibly their execution activity.
36.
The next matter. Two matters are, my lord, being taken up together.
Who has filed 36? You have filed.
It's possibly they are, my lord, I mean, briefed.
Next, Tikana. Is it coming for the first time?
No, no, my lord came up, and my lord, desire was we should, my lord, put in a legible copy, which is why, my lord, the matter was fixed today. Next matter is whether not. দুটোই কপি পেস্ট করে দিয়েছে নেক্সট এর কস্ট সাইকেলটা দেখি না কতক্ষণ ধরে
Next matter क्या? 36 है.
next one is minute mice 36
Oh, 36. Deposit the money.
yes so minute one is 34 one is minute first day of mine
This
but
is,
I have not yet been
203 is 34.
yes
And AP 204 is probably your 36.
should be minute 36
UDTA.
but I found Miller the supplementary affidavit minute it has been copied Miller from the other and pasted in the Miller second matter. Both says Miller 34. Kindly Miller ignore Miller that mistake.
204 is your 36.
Yes, Miller.
So in 36, deposit the money.
Miller, let me not move it today. Miller, I'll come back. Miller, I'll just see whether Miller there is an element of fraud or not. Whether I can take refuge under Miller the proviso.
So I'll only record that you have filed your supplementary.
Yes, Miller, kindly do so. Miller, may put in Miller the legible copy in the other matter also. One is 34 Miller. I have filed a supplementary affidavit.
Supplementary affidavit in both the matters you're filing?
Yes.
Learned counsel for the dono mein kar dena order ka. Learned counsel for the petition has filed the supplementary affidavit. The same is taken on record. Dono mein same. Let this matter be listed on. When do you want, Mr. Ben?
A fortnight Miller.
After 2 weeks.
Grateful. Great.
I appear for the award holder, my lord.
I'm opposing the application.
This is my application to seeking lordship's leave to withdraw and encash cash security and bank guarantee which has been submitted by the award debtor. The prayer, my lord, is at page 18.
Yes.
At page 29, my lord, by an order dated 30th January 2025, the award debtors were directed to provide security for a sum of rupees 4 crores, 2 crores in cash and 2 crores in bank guarantee. My lord will find the direction at page 35. In page 35. Second paragraph, my lord. This court deems it fit to direct a sum of rupees 4 crores to be secured by the petitioner to stay for stay of the award and stay of the execution proceedings. 50% of the said amount shall be secured by furnishing a bank guarantee to the satisfaction of the learned registrar. The bank guarantee shall be kept renewed from time to time. The remaining 50% shall be secured in cash before the learned registrar original side. The learned registrar original side of this court shall deposit the amount in an auto-renewal interest-bearing fixed deposit with any nationalized bank. My lord, this was complied with. The last extension was provided by a communication at page 50, my lord. Page 50, my lord. We'll see this is a communication from the registrar original side to the advocate and record of the award holder. where the bank guarantee was renewed until 28th February 2027. And my lord will also see that the cash security was provided, which was recorded by the registrar original side at page 46. My lord, the award holder is now in some dire need of funds, hence this prayer has been made before your lordship. I have decisions with me which support the fact that it's up to the court's discretion to permit the award holder to withdraw and encash cash security. If I have my lord's leave, I can place those decisions as well.
Lordship, I'm seeking for some time to file an opposition to the application on the question of maintainability, Lordship.
Why? Why it's not maintainable?
Lordship, also on merits, apart from the merits, Lordship, on maintainability point, I shall like to argue.
That's what I'm asking.
Lordship,
Why
this
it's
is
not
section 36 is the scope of the award debtor seeking a stay. Lordship, that was already granted, and
Yes.
when the order was passed, no liberty was sought to withdraw the amount.
You don't need any liberty.
Lordship, that has attained finality. Now, Lordship kindly comes to the prayer they have sought.
Yeah.
Lordship, there is no prayer for modification of the order
need for
passed earlier, Lordship. What has
This
Lordship
is
now?
This is done. It's almost on a daily basis where the money is withdrawn by the
Yes,
person
Lordship. But
concerned
this
after-
prayer, Lordship, is little different from what the usual prayers are, Lordship. Lordship will kindly come to the prayers.
Page 18,
Page
my lord.
18 onwards.
Yeah.
Lordship, this is the prayer this is the amount which is lying with the registrar. I have no difficulty, provided the interest that is accruing every year, that is also secured by they have prayed for a bank guarantee to be furnished. I have no problem with that. Now, Lordship will kindly come to prayer B. An order be passed directing the registrar to encash I'm sorry, prayer C. I'm aggrieved by. This is the bank guarantee they intend to see. An order be passed directing registrar original site to seek encashment of the bank guarantee dated so and so by our bank, that is by Shinhan Bank, for the sum of rupees 2 crores. An order be passed directing to issue appropriate instruction direction to the manager of my bank for remittance and transfer of the sum to the designated bank account of the applicant bearing. Lordship, this is where I oppose that this should not be done, because the bank guarantee that has been furnished by my bank is on the basis of my relationship with the bank, and only on the satisfaction of which the bank guarantee was issued on payment of a margin amount. Now, if the applicant before your lordship seeks to withdraw that, the entire financial basis on which the bank guarantee was
He's going to
furnished.
protect you. He's going to put an interest. He's going to put a FDR in the bank guarantee. If you see, he has already said that.
Lordship, he intends to transfer to his own bank.
Please read B.
Yes, Lordship.
Upon the applicant furnishing a bank guarantee for an equivalent sum covering the principal amount as well as the interest accrued therein by way of security or in such other form as this court may direct as a precondition.
Lordship is reading prayer B. Lordship, that is with respect to the cash deposit.
Yes.
But with respect to the bank, the Lordship will remember the order was in two parts.
2 lakhs and 2 lakhs.
2 crores and 2 crores. 2 crores in cash and 2 crores in bank guarantee. I have no problem with the cash being withdrawn subject to being furnishing a bank guarantee, replenish it along with the interest that is accruing every year. But with respect to the bank guarantee that has been furnished by my bank, Lordship, this relationship with my bank on the basis of which this bank guarantee has been furnished will be jeopardized if the applicant is angry.
Learned J1. This is an application taken out by the...
One prayer may I make?
Yes.
My lord, since my lord, the other part of the prayer she is not agreeing. The portion which she is agreeing, will your lordship consider giving me some relief today, my lord? Because I'll put in a counter guarantee.
Lordship, may I
or
come
my
back
lord, the
with my
entire 2 lakhs
opposition?
which I
That's
Actually,
fine, ma'am.
consolidated opposition, then.
This is an application taken out by you're the respondent, right?
I am the award holder respondent.
Respondent in the pending proceedings under section 34 of the Arbitration and Conciliation Act, seeking permission to withdraw the security of 4 crores furnished by the petitioner pursuant to the order dated 30th January 2025 upon furnishing equivalent substitute security. Full stop. Learned counsel for the respondent seeks and is granted liberty to file affidavit in opposition. 2 weeks time to file affidavit in opposition. Reply to the same if any within 1 week thereafter. List after 4 weeks.
Great. My lord, so far as prayer A and B, my lord, that
We'll grant both. Let her file. Let her bring her stance on record.
Great. Obliged, my lord. 34 may be heard out, Lordship. There is this a prayer, Lordship. The basis on which such prayers are made, Lordship, is for
Award is of which year?
34. 34 is
Award is of which year?
what is, my lord?
of what is of 2020?
9 January 2024.
We'll see.
May it please to Lord appear for applicant award holder in item 17 and 18.
Item number 70. I'm sorry.
17 and 18, Lord.
79. Yes.
Lord, my prayers are identical to what my Lord just heard. Lord, I am seeking your Lordship permission and order, Lord, to withdraw the amount. Your Lordship, the reason, Lord, I have cited already in my application. Lord, I have 60 crores of order was to Lord comply with. Lord, I'll be Lord furnishing bank guarantee equivalent to the amount which your Lordship will be pleased to.
17, 18.
Yes, Ms. Pandey.
Your Lordship, I'm opposing the same. Allows me to file a short opposition, Your Lordship.
My lord,
Because this is not a private limited company.
So what?
no,
Your Lordship, what are their balance sheets and other details? They have not given.
They will furnish a equivalent
Bank guarantee. Yes,
Your
Lord.
Lordship,
I'll furnish bank
short
guarantee.
affidavit within 3 weeks. I'll file my affidavit. Your Lordship.
1 week. If I give you time, 1 week. There's no question.
Your Lordship, 1 week's time may be granted.
So, take down. There's an application taken out by the respondent award holder seeking modification of the order dated 22nd December 2025, whereby a conditional stay has been granted on the award dated 14th March 2024. Upon the award dated depositing a sum of rupees. How much is the amount?
this one is 3 crore 8
3
lakh
crores
8 lakh.
0800000 with the registrar original site. Learned counsel for the
And 17 amar ho gaye na.
award. You're the award holder.
I am the award holder, my lord.
I'm the one.
Learned counsel for the award data. GA01 award data. Section is granted 1 week time to file her affidavit in opposition. Reply to the same if any within 1 week thereafter. List after 2 weeks.
Lord, 17
18 is also a similar matter.
similar matter.
18 you're for
Lord, I am for
similar order.
The amount, my lord, will
How
be
much is
different.
the amount?
Lord, amount will be changed.
Sorry? Amount will
Lord,
change.
amount will be changed. Lord.
And order date
Order date is 2nd December only.
Lord, order date is same.
and the award date
18th April. This one is 18th April 2024.
18th April 2024 and the sum is amount
1 crore 32 lakhs 49,605.
ठीक है ये बता दो ये
My lord is keeping the matter
after 2 weeks.
grateful.
I'm so good.
My lord, 19 and 21, my lord, may be taken up together. 19 is my application under section 36. 21 is my application under my lord, section 34. I appear for the West Bengal Housing Board. My lord, I am the award debtor. Award is in excess of 100 crores. Award was passed on 8th of November 2025. Well, I have asked them to give me instructions to how they wish to secure the amount. Well, kindly give me 2 weeks time. Well, I'll come back with instructions. Then we'll also proceed with the hearing of the 34 application after I secure the amount.
No, Mulad, I have already passed an order. Affidavit of assets have to be filed. So, well, there should be no stay. Let them file an affidavit.
I'm not saying
100 crore award, Mulad.
No, Mulad,
I'm
no,
This will be a ground.
Mr. Saab, I will only say it if you secure it.
That's right.
There's no question.
Yes,
of saying
Mulad,
that.
I have
100 crore award,
Mulad,
Mulad.
how I
100
will
crore.
secure, Mulad, I just want instructions
Yes,
in that.
that's what
there's a new government.
that's what I also
Yes.
understood, that you're not
No,
asking
no,
for a
absolutely, absolutely,
Yes.
Mulad. I will secure it. I just want instructions from the new government as to how we intend to secure it. Mulad, there's a change in government.
That's fine,
Well,
Mr.
2 weeks.
Chaudhary, we'll wait. Learned
I just pray
Lordship.
for 2 weeks time.
Lordship, read the synopsis, Mulad. There is no ground. Anyway, Mulad, Lordship,
No,
he's
I-
asking about
that-
time,
that-
Mulad. I can't say no, Mulad. Let him ask time.
It is not of any prejudice to you.
No, no.
Learned Counsel for the, you're the award debtor.
Yes, Mulad, I'm the awarded.
Award debtor seeks and is granted time to take instruction in seeks and is granted time to take instruction. Let this matter be listed as to how he will secure the award holder in terms of section 36 of the Arbitration and Conciliation Act. List after 2 weeks. Yeah, it's quite
Great.
good. Learned senior counsel for the award debtor states that with the change in the government, he needs some time to take instruction. Let this matter be listed after 2 weeks.
Grateful. Well, item number 21 may also be listed after 2 weeks. That's just 34. Yes, grateful. Very
34
grateful.
Grateful.
Award is of which year, Mr. Chaudhary?
The 2025.
2025.
8th November 2025. November 2025.
Just I'll list along with that. Okay, what is it? The 36, wait a minute. 20 is, I think, 36 again. 36 confirm. 19 है ना? So 9 and all are connected. 19 and 20. 19 में ये order कर दो and 21 list along with.
Calling your pen.
Item 20, Your Lordship, small matter. Same withdrawal. I'll take a time to file opposition.
Same order कर दो जिसमें
Only
but
2 weeks
give-
may be
give-
granted.
Why-
1 week, Your Lordship, same. There are grounds on which this can be sustained. He is himself stated he's 68 years.
My lord, I appear for the decree holder, my lord. This is my.
You appear for Union of India.
Your Lordship, I am not opposing prayer B where they are asking for expeditious disposal of the section 34, my application. Prayer A, I am opposing, for which I want to file an
My lord, the
opposition.
issue is, my lord, that this is from 2018, my lord. This has been kept pending, my lord. There have been
We are ready to
various
argue the
occasions
34.
What is of which year?
the 2017, my lord, November 2017. My lord, 2018, this award was stayed, my lord. Since then, my lord, my lord, the respondents have only taken time on various occasions.
We are ready with the section 34 hearing, Your
But
Lordship.
the issue is, my lord, the
The
petitioners,
councils
my
have
lord, the
changed now.
my lord, it's a partnership firm. Both
Let me allow the application.
Your Lordship, he himself has stated he's 68 years old. It's a partnership firm. They themselves have stated they are undergoing hardship and their financial condition
They
is
will
not
secure
great.
you with a equivalent.
Your Lordship kindly allows me 1 week's time. I'll file my opposition. Same prayer like 1718.
Take down GA. Learned Counsel for the supplement. The award holder has filed the present application. GA1 seeking withdrawal of the amount deposited by the award debtor in terms of award dated.
my lord,
Award dated, Your Lordship, that 16th August 2017, which was corrected by 21st November 2017.
16th August 2017.
17. And corrected award 21st November 2017.
And which was amended by order of 21st
21st November.
2017.
Yes.
From 7.
Amount is 33,34,950.
The
और तो
petitioner
deposit
seeks
इतना ही
to
होगा,
withdraw
तो वही withdraw करोगे ना, cost थोड़ी ना कर लो.
the deposited amount of rupees 33,34,950 with the registrar original side. Full stop. Learned counsel for the respondent seeks and is granted 1 week time to file an affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 2 weeks.
Obliged.
There are supplementary.
What is this?
It is not being
There are
served.
certain documents, whether some prescriptions that we would like to rely on as well, my lord.
Supplement in GA, you're filing the supplementary affidavit.
Yes.
Is there a need for this?
My lord, certain prescriptions that is all there is, my lord.
As long as you're securing the money, there's no problem. Why do you want to file this?
Very well, my lord. I shall take this.
Then they'll take time to file their reply to this also.
Yes, my lord.
So far, item number 22 is concerned.
Yes, Mr. Yes.
This is a case where the award has been passed on. This is very unfortunate for the award holder. Why I'm telling you for a moment, my learned friend will take.
But I am for the petitioner in this matter, Miller.
The award has been passed on 31st of
I am for
December
the petitioner in
2005.
this matter, Miller. This is basically the
2005.
second round.
I बोले the award
This
has
is
been
the second
passed.
round of litigation, Miller. The award, Miller, since it's my petition, Miller,
Yes,
may I be
Mr.
allowed to say
Chakravarti.
something?
Yes, tell me. Yes,
Miller.
yes, tell me.
Yes, Miller. Yes, Miller, this is the second round of
Madhusudan
litigation, Miller.
Saha
Once
is
they have,
also-
Miller, won the award, Miller.
Yes.
Yes, Miller. The 1.32 crores was the value of the Miller work order. Miller, pursuant to the award, Miller, we have paid us further sum without prejudice to our rights and contention. The total amount is now 1.42. We have already paid. Thereafter,
Yes.
we have preferred a challenge against the award in section 34. That section 34 was dismissed. Assailing that, Miller, we went before the section 37 court. There, Miller, there was a stay on the award. And finally, Miller, the section 34 order, earlier order has been set aside, and now it has been sent back for further hearing under the commercial side, Miller. And therefore, Miller, both us, Miller, myself and Mr. Madhusudan Shah, Miller, both we have to file, Miller, the new set of Vakalatnama and other things. And I was checking the CIS and wondering that Mr. Madhusudan Shah has also not filed any Vakalatnama. I will be, Miller, filing the Vakalatnama.
My
Kindly give me
advocate on record.
1 week's time, because the change in it now it has been converted to. Yes, obviously, your advocate on record, and my advocate on record will file the Vakalatnama for the petitioner.
So far, I appreciate that.
In the
but this is
commercial
technical-
division, it
this
has
is a
now been
technical-
transferred. This complied.
It's a technical issue, no doubt of that. Whatever the rule, we have to comply with that. Kindly appreciate that this award has been passed on 31st of December in the year 2023. Against that, they have preferred an appeal only on the score that since it's a non-commercial matter, it has not been converted into a commercial matter. On that score, the matter has been relegated, not on merit. Nothing has been made. Only on that score. If you lordship kindly see that order where it has been specified that since this non-commercial matter has not been converted into a commercial matter, this matter is to be placed before the single bench. But this is the situation at the moment. Lordship kindly fix up any date subject to your lordship kind approval so that the matter can be heard out.
Keep it after a week. That we are keeping it
Any day.
Second half, no? Let's start with this one.
But Miller, instead of Miller, next Friday, Miller, can it be after 10 days, Miller?
Delay করছো
It's for you.
Thank you.
No. I am ready with the matter. I have argued the matter before the 2 division benches for 3 days altogether. So I am ready. Not that only thing. Is a Miller.
The judgment passed by the division bench.
Yes.
After 10 days, Miller.
After 10 days. Okay, not next Monday. Next to next Monday, 3 p.m.
I'm deeply obliged. But this is the order we kept on the record.
You'll see it.
I'm deeply
Obliged, Lordship.
We'll try to hear these 34s.
Yes, certainly.
My God, look at this.
Yes, 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 certainly.
Look at the color; it has already
Color,
changed.
that's
And
what
they have got their money, Milord. It's not that they are so much aggrieved.
Now the award holder has become almost 80 years old.
Not that Mr. Shah is so much aggrieved.
call the
Appellate side matter, item number 1.
I'm for the petition.
And for the alleged contempt on lordship led by Mr. Banerjee, Shondipan Banerjee.
My lord's order has not been complied and no compliance report has been submitted to the judge.
Lordship, I have one report, Lordship, but marginal portion has been demolished because Lordship, whole
My
building,
instruction to that effect. nothing
whole
has-
building, let me complete. Whole building is occupied, Lordship.
But Ms. Das, you were supposed to file a report.
Yes, Lordship, I have.
Where's the report?
But compliant,
File a compliance, complete compliance report.
but
What kind of report is this?
Lordship,
Report of
whole
where?
building is occupied. We are repeatedly intimation to the police authority, Lordship. How will I comply the? Kindly give some more time, Lordship. Mr. Banerjee went to Puri, Lordship.
This is no report.
Yes, Lordship. One report, Lordship.
Nothing. This- No compliance.
Compliance has been not
You have to
completed,
do the
Lordship.
compliance, then I'll call the commissioner. I'll issue contempt against him.
Lordship, kindly directed to police authority, Lordship. Kindly.
Police authority, Ms. Ray, that is for you.
Whole building is occupied, Lordship.
That's for you to deal with the police authorities. I have passed an order.
Kindly, Lordship. Page number.
Mr. Banerjee is not here. I'm not troubling you. When is he coming? When is he coming?
Kindly next week, Lordship.
All right. We'll keep it after 2 weeks. File all the letters which you have written to the police authorities. Nothing is on record. Take it back.
Lordship.
Learned counsel for the respondent seeks and is granted further time of 2 weeks to file affidavit of compliance. कोई डेट फिक्स किया हुआ पहले का?
Lordship, kindly directed. Lordship.
हाँ हाँ कब का डेट कब का है? 23rd. तो आज के 7 नहीं, वो तो नहीं हो पाएगा. हाँ आज के बाद कोई डेट है? हाँ तो वो देखो इसमें 7. Have you made all right.
Lordship, one more indulgence, Lordship.
Learned counsel for the respondent. Who appears for the state in here? Give a copy to serve the state. We'll pass direct.
Grateful, Lordship.
We appear in
State
the
also.
read petition.
Yes.
And
Contempt petition. Give a
Contempt
copy to the state.
contempt petition, I have not made a contempt against the state. I made
In
against
read
municipality.
petition,
Why?
There is a municipality may given an undertaking.
That's all right. Even they have a role.
grateful.
Give notice to them. Anyway, you write to the police authorities. If they don't do it,
I
you see.
repeatedly, Lordship.
Nothing is on record, Madam Ms. Ray. What have you put on record? Nothing is there.
Lordship, kindly, Lordship, page number 7, Lordship.
Don't file this kind of a report. I'll call your commissioner. Keep it on the 7th of August. 7th of August.
State action. Container action. Gratefully, Lord.
Item number 2.
I may appear on favor of the respondents, my lord, in this matter.
The order dated minute.
Yes.
Order dated minute 23rd May 2025. Milord, the matter was disposed of 21 Milord.
Mr. Basu, the same one.
The same one, Milord. Here, Milord, the court had directed, Milord. There was no confusion, Milord. Kindly cease.
It's the order of 23rd of May.
No, yes.
Right?
Yes,
Page
page 20.
Parent order, my lord.
Page 20, Milord.
Paragraph
Milord 5. It is the statutory duty of the respondent municipality to ensure that public streets remain free from encroachment. In the instant case, there is a categorical finding by the executive magistrate that 7 feet wide common passage was constructed by the respondent municipality for the unhindered use and enjoyment of the general public. Even the compliance report submitted by the municipality acknowledges that the respondent number 7 and 8 have encroached upon this public passage, thereby causing substantial inconvenience to the petitioner and the public at large. Despite such acknowledgement, yes, Milord.
My lord, we have filed our compliance report, my lord, 2 compliance reports.
Yes, Milord. The compliance is a pseudo compliance, Milord. I tell your lordship that, Milord, exception, Milord, I have filed a photograph showing, and it is apparent, Milord. It is apparent page 6 of my report, of my exception to the report. My lord, kindly takes pain, Milord, to page Milord, piece 1. Kindly sees, Milord, this was initially 7 feet. This was not. It's categorical finding of the court that this was encroached by respondent number 7 and 8, and page 6 and 7. These are the photographs, Milord, which categorically states, Milord, it suggests, Milord, that 7 feet, Milord, this has been reduced into, Milord, 4 feet. On the date of filing of the writ petition, I was in a better position. Before that. But kindly sees. If I can, Milord, bear the cost if you 7 feet has to be maintained. And Mr. Shadhan Chakraborty, the alleged contemner, also, Milord, filed a suit before the court below, as well as executive magistrate, Milord, suppressing your lordship's court's order. I have a specific instruction from my client.
Yes.
Yes, my lord. My lord, I already filed a compliance report, my lord. In my compliance report is page number 6 and 7, my lord. They contradict the views of the petitioners, my lord. My lord, in the page number 6, there was when the matter was filed, there was a fencing, iron fencing over that, my lord. Page number 6 was the existing of the iron fencing. And page number 7, the process of the removal of the iron fencing, my lord. Page number 8 was the, my lord, already removed the iron fencing, my lord. Then page number 9 and page number 11, my lord. Kindly come, my lord, page number 11. The 11, my lord, the total 7 feet was cleared by the municipality on that before the compliance of the affidavit in compliance. And thereafter, my lord, the allegation was made, my lord, by the petitioner that we are not remove anything, my lord. This is the page number 11 was the everything is removed and the common path was also removed, my lord. My lord, page number 3 of the exception of the petitioner filed by the petitioner, it is reflected by my lord. Page number 3, paragraph number 4, my lord. Page number 3, my lord, of the exception filed by the petitioners, my lord. In paragraph number 1, from the bottom, 5th line from the bottom, the by the alleged comma, a new encroachment has been made out when 10 feet common passes. Every time the municipality has gone there and removed their encroachment, but the neighbors were again, if the encroachment, there is a new cause of action, my lord. What the municipality could get, my municipality was
Order is clear.
Sir, what is the municipality doing? They will allow the encroachment to take place.
No, my lord, absolutely
How
not.
can
My
you make that submission?
lord, every time municipality.
This is your job.
No, no, my lord. My lord, again, my lord, the municipality facing a civil matter, my lord, which Swapon Chakraborty was filed and restraining the municipality do not take any action, my lord, from the civil
Where's
court.
the order?
My lord, the petitioner, my lord, the petitioner also party in this in the civil suit, my lord, being number TS number 167 of 2006.
Civil court has no power, my lord, to suppress the High Court.
My lord, that I know, my lord.
The order which has been passed.
My lord, because of the some medical emergency, I do not physically present in this court, but the petitioner also have the order, but and serve the petitioner also, my lord.
Put the order.
My lord, in next course of the day, my lord, if my lord permit that, I will submit that order also. This is the main.
Kindly record an
My lord,
order.
as per the page number 11 of the compliance, my lord, the everything is removed by the municipality, my lord.
The compliance is replete with incorrect
Respondent
submission.
states that the order passed by this court was duly complied with and an action taken report, compliance report has been filed indicating the iron fencing which has been removed and the iron fencing / encroachment being removed, full stop. An exception to the said report had been filed by the petitioner, wherein the petitioner alleges that the passage is still not free from encumbrance and is encroached upon, full stop. Learned counsel for the respondent states that the neighbor had approached the civil court. Which court?
Civil court, this is Barakpur.
Barakpur, my lord, Civil Judge, Junior Division, Barakpur.
Had approached the civil judge, Junior Division, Barakpur.
TS number 167 of
Your lordship,
2026.
By way of filing a TS
title suit 167 of 2026.
167 of 2026.
Well, they are the different neighbor.
Wherein some restraint orders have been passed. Learned counsel for the respondent seeks and is granted liberty to file an additional affidavit bringing on record the orders passed in the said suit, which is coming in way of the respondent in taking any further action. Full stop. List after 7th August. Within a period of how much time you want?
My lord, because of the changing scenario and the two containers are also removed.
Period of 3 weeks.
And we will place by 7 days. And we will file 7 days, a reply.
3 weeks and
1 week.
1 week thereafter. Additional affidavit, 3 weeks, reply to the same if any within 1 week thereafter, list after, इसको कर दो, अगस्त में लास्ट का डेट दे रखा है अभी तक 7th है ना, you give it after 28th August.
Deeply obliged, my lord.
Deeply obliged.
28th August. 28th August.
Deeply obliged.
Indulgence. May I have the liberty, my lord, by reason of if your lordship passes an order directing, my lord, any special officer to be appointed at my cost, so that, my lord, I can lend.
The order which has been passed.
I am extremely grateful.
Item number 3.
Item number 3 to 10 are identical matters. These are all contempt applications where your lordship's order has been violated. The municipality says they have done their part, but the director of local bodies, lordship, on the last occasion your lordship had seen that they were absent. They are absent even today. It is
Who's appearing for the director?
We are for the municipality. Last 2
Who's
occasions.
for the director of local bodies?
Lordship, we have given a notice again, stating that the matter will be before your lordship
So
today.
who appears? Generally state appears? Who
State appears, but who will appear on this occasion? There's a new panel, so we do not know. Lordship would kindly pass a rule. Unless a rule is passed, they will not come.
We were directed to submit the compliance report.
Yes.
So for our part is concerned, we have done our job within the stipulated time as directed by your lordship in the.
Lordship, I shall go through the compliance report. I have not been given a copy.
Where's the compliance?
If it is, Lordship, if there is anything we find, we'll use an affidavit.
Municipality is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file her objection to the compliance report, to the report. August, list on 20th August. None appears on behalf of the state. The let court notice be issued to the learned, who should be the Advocate General?
Or the government pleader, any one of them, Your Lordship.
Government pleader. To the government pleader.
20th August.
To appear on the next date.
No,
Versus-
copy.
With the contempt.
Well, up to 10 similar matters, I am filing my
Compliance affidavit sab mein le lo, same order.
Same order in all the matters.
10.
10.
Who have you served, madam? You have served their office, AG's office.
We have not the AG's office. We have served directly on the director of local bodies.
The AG's office, cut down that. Learned counsel for the petitioner will serve the respondent, director, local bodies, the as well as the Advocate General office, so that adequate representation is being made by the state on the next date.
Lordship has fixed 20th August.
28th.
28th.
Well, I have served the copies of the minute.
Yes.
Compliance.
Yes, 11.
I'm for the petitioner, my lord.
Yes. Madam. It's fresh.
Yes, my last occasion, Mr. Hunang Bhattacharya appeared for the Association Municipal Corporation. As per lordship direction, I have served him a copy. But somehow I think he's absent. Actually, kindly fix another date, my lord. Some probably is.
All right. At the request of the learned counsel for the petitioner, let this matter be listed on 7th August.
Lordship.
7th August. At the request of the learned counsel for the petition, let this matter be listed on 7th. Tamal, you are taking it. Next.
Item number 12.
I am for the petition.
Yes.
Pursuant to your lordship direction, I have served upon the contempt of the
Item number 12, 13, 14, 15.
Yes.
Identical, my lord, probably, my lord. And in this matter, my lord, the Mr. Parashar Buddhi is appearing on behalf of the alleged contempt, my lord.
Yes.
So, my lord, he could not come, my lord, due to some personal difficulty. And it is as per the instruction.
Report. Where's the report?
My lord, it is with him, my lord, and he could not come before your lordship. And it is as per the instruction I received, my lord. He is.
Appear for who? State of West Bengal?
No, my lord, alleged contempt, Tahirpur notified area.
Yes. That pension matter, my lord.
Yes, yes.
And it is as per the instruction I received, my lord, that it is in process of compliance, my lord. Kindly, my lord, allow me 2 weeks, but 3 weeks accommodation, my lord, it will be in meantime, I will file a compliance.
All right. Proxy counsel so and so appears and states that the main arguing counsel, Mr. Who's the main counsel?
My lord, Mr. Parashar Buddha.
Mr. Parashar Buddha is in some personal difficulty, is indisposed. He prays for an additional time of 3 weeks to file his compliance affidavit. Let the same be done within 3 weeks. List after 20th August.
Grateful.
May I file evidence service of all the matters, ma'am?
Till, this is still?
May
item numbers?
This 12 to 15, madam.
12 to 15.
May I serve my file the evidence service, madam?
Affidavit of service taken on record.
Madam, all the matters, madam.
Yes. अलग हेल्प कर दो 16
16, 17 and 18 all are similar matters, my lord.
Yes.
Pursuant
My
to
lord, I am on behalf of the municipality, my lord.
Yes.
My lord, the municipality has taken all the steps, my lord, and they are uploaded copy has been already completed the IOPS portal, but the director of local body did not issue the PPO, pension payment order.
Where's your compliance affidavit?
There was a direction, my lord, within 2 weeks, my lord, the PPO and my lordship. Kindly see page 27, my lord's order. My lord, I have served
Serve the new people. If the panel change,
Yes.
serve upon them, then the compliance. Where's your compliance affidavit, Mr. Das?
Because director of local body till now did not issue the pension payment order, they have communicated the municipality, they have returned the file, and they have directed to upload the all documents in the IOPS portal. That the municipality has already uploaded the IOPS portal. Next day I shall file a compliance report what step municipality has taken, madam.
All right. Learned counsel for the respondent, municipality seeks and is granted further time of seeks to file his compliance affidavit. Fresh notice should be issued to the director of local bodies as well as the concerned lawyer for the state to assist this court.
State upon the GP, my lord.
16, 17, 18, same.
Notice on the government leader.
The matter will appear, my lord.
On the next day.
16, 17, and 18 are same, madam.
Same order.
My lord, matter will appear, my lord.
28th August.
20th August. My lord,
Wait.
all three matters, my lord, the affidavit of service. My lord, affidavit of service will be kept on record.
Service kept on record.
Grateful, madam.
Yeah. हो गया?
Your Lordship, we'll take up original side matters, commercial division of the monthly list.